President and has agreed to collaborate with me this morning. So I'm just going to lay out, I think, sort of three different themes or areas that we can think about exploring, and then we're just going to turn it over. I think we'll use sort of Chatham House rules or whatever you want to call them. Just indicate when you want to speak, and actually we are being recorded, so the rule is not Chatham House. We're being recorded. We may or may not publish it depending on how it looks as text. But just indicate when you want to speak, and Dave will give a list. Okay, so I'm thinking about this discussion in sort of three different ways. The first is kind of following up on the question about the doctrinal discussion of the first panel, which is why does the case matter? Does it even matter? How does it matter? For whom does it matter? When you think about this, the internal question, which Bill Duncan and David Stewart talked about yesterday in terms of its effect on executive behavior. What about Congress, the states, and the courts? And one of the things you might think about, I think, Billy raised the question of the effect of race on all of this. And then the other dimension of it is sort of how does it matter externally? And I don't know if anyone has thoughts about that. How do our partners in negotiation see these issues, not just the jury in Holland, but sort of broader questions, including criminal prevention and so on. And does it have any effect, or should it be having an effect on those iterative interactions that might develop, or have effects on the development of international law more generally? And then there's sort of the Judith Resnick dinner party question. Can we envision needing this free Holland anymore? I think the polar bears were raised last night, and maybe there's some other issues that we can think about. Some of the other sort of more specific follow-up questions for the second and third panel, coming out of this discussion of the power of the states and some of the things that are going on at the state level. One of the things we didn't talk about, since it's a federalism discussion, we didn't talk about some of the separation of powers questions. If we're having oversight of these state activities, should there be a role for the courts? Duncan presented to me for the executive senator, and we might want to think about whether that's the right approach. And on the third panel, Ed raised the question about sort of the ICJ, and I think this question of what does legal pluralism tell us about the ICJ should lead us to a discussion about the status and role of public international law in this discussion of multiple layers of governance and sources of law. I sort of, made the case for, as I was thinking through the day, maybe we should be essentializing international law, maybe not the international. At least I was hoping to have a conversation about this. And part of that is maybe thinking about whether internationalists, those who are committed to some sort of international project, and there may only be a couple in this room, should they be worried about the pluralist or intersystemic governance approach? And the way I was thinking about this is, we can all see this as part of, or maybe we could see this, or should we see this as part of some of the broader critiques of public international law, coming both from sort of the ideological left, post-colonial theory, empirical approaches to international law, feminist critiques, and so on, including, in fact, cultural relativism, and from the right, which is sort of the non-privileging of international law generally. So, is this part of that movement, or is it something else altogether? Sort of the third thing I'd like to do in the discussion, if we have time, is kind of the self-assessment. Where are we going with all of this in terms of the field? And there's two ways to think about it. One is, I think Peter mentioned in his comments yesterday, the sort of intra-field engagement. Federalism, domestic federalism theory expanding into international, doctrinal constitutional debates being informed by developments in international legal theory, and maybe some other synergies that are going on in scholarship. And the second part of it is interdisciplinarity. We've had some of that here with rational choice, political economy approaches, Paul and Ilya. And those approaches, I think, suggest perhaps thinking about importation from perhaps social and behavioral economics as well, to sort of refine the interdisciplinarity that's happening in the field. So those are the broad themes, and just let us know if Dave, if you want to say anything, and open it up for the broader discussion.
I'm going to take names here, so anybody who wants...
you want to do those in order with
Let's start with the first part one, which is why does it still matter? The case, the time, and the debates.
I mean, I think this is really following up on Duncan's comment yesterday, and also Ed's response to Duncan's comment, which is it still good law? And I think one can make a pretty good case that it's not. To the extent that you have a consistent practice from the treaty makers under which they seem to be acting on a premise that they don't have the powers that they would seem to have on the reserves. So I don't know about the polar bears. The only other example I can think of where Congress, I guess at least maybe poses the step 2 question, has acted on the treaty powers with respect to the criminalization of female genital mutilation. But otherwise, when you see the human rights treaties coming through the Senate in particular, and of course the packages, the RUD packages composed by the executive branch, there's a systematic effort to, in effect, not use the treaty power to constrain the states in any way. And there, in the mid-90s, I worked with the Lawyers Committee on trying to get implementing legislation for the ICCPR introduced into Congress. And we would go in and talk to the Democrats and just get these blank stares when we suggested that this was something that was in their power to prohibit the execution of juvenile offenders and otherwise reduce the effect of the reservations package. So it seems to me that the constitutional consciousness of the treaty makers does not reflect the bottom line of Missouri. And of course, under alternative methods of constitutional interpretation and formulations of law practice, and for some of us, takes on a precedential status in a way that you just say it's in effect, we reflect this consistent long-standing practice.
My question was very similar to what extent folks have a sense of being curious. Like, what's the historical record of reliance on the treaty clause in the Holland versus Missouri sense? Given sort of Peter's phrasing of the recent history, I wonder does anyone have a sense of it over time? Have we seen any pattern? Like early on in the years immediately after Holland, was there any sort of evidence or any history of that? Was there some pattern that increased and fell off? Or in terms of assessing its significance, looking at historically, have there been the ebbs and flows of reliance on that kind of Holland versus Missouri?
It is actually, if you want to actually go back, I actually did all the way back to the framing, and you find if you're looking, for example, I was looking particularly at the executive branch's position, and there's certainly an ebb and flow, right? Administration to administration, sometimes within administrations, depending on the treaty, there will be articulations of Missouri v. Holland, freedom from limits versus somebody saying, actually, we don't want to do this treaty because there are limits, and the limits vary between the subject matter limits or international concern test. I just wanted to kind of caveat, because I don't think my comments to Carlos and to Ed yesterday was not to suggest that the executive has decided Missouri v. Holland is going to be law, but that you need to account for that tit for tat in this notion that the executive somehow has its own voice and its own sense of what the Constitution requires and how that fits into this discussion. Because I think you could make the argument as Ed did, if you look at the practice and you say Missouri v. Holland is going to be law, but if you actually look closely at what the executive is doing, they're never saying, well, we're legally required to have a federalism clause or federalism understanding or federalism reservation or whatever. It's more like it's a matter of policy. And indeed, somebody was asking, you were asking the external question. My one anecdotal story is, so I was in France when we were negotiating the Cybercrime Convention, and they wanted to regulate, they wanted the provision of require regulating all cybercrime, and we said, interstate cybercrime might be a problem, and we'd rather have a federalism reservation clause in the treaty that allows states that are federal states to exempt out of what they can't regulate it. And literally, the French deputy legal advisor says, but you have this case. Missouri v. Holland that establishes you have the authority to do this. And I was like, well, it's true that he would live up in an international negotiation, but, and then, tried to have to, thread the line, because I think, I don't think the State Department would say Missouri v. Holland is no longer good law. I think the State Department would say federalism is a value that needs to be considered in treaty negotiations that will often lead the U.S. to self-limit what obligations it accepts, but they probably would like to preserve, both ways, right? Probably both ways, where they can both, tell externally folks, oh, we can't do this, but internally want to be able to reserve the right, if they think it's necessary, to fall back on it. And I can talk about the polar bear.
Well, can I just ask a follow-up to that? Because I'm curious to know whether there are some measurable effects on the negotiating process, or are there stories, maybe Dave has some information on this, where this is, someone trots this out and, this sort of breakdown in discussion. What about Missouri Holland? Timing and hawing on that question.
I think Duncan has stated it correctly. I'm not aware of a view within the State Department, certainly that Missouri v. Holland isn't good law. And actually, I'd like to put on the table a question I asked a number of people. What do you think would happen if Missouri v. Holland goes back, as I'm sure it will, to the Supreme Court? What would this court do, rather than looking at the constitutional theory? But there's certainly a policy disinclination to test it. I don't think it's necessarily because we don't think the court would rule the same way, but in my experience, it has to do, in addition, with the reluctance of the Senate to use treaty powers to change the law. My experience, mostly of the human rights experience, a lot of those rubs in the Federalism reservation and the others were generated by a conscious decision not to use the treaty power to change the law directly. I don't know that has to be directed in the sense of Missouri v. Holland and its validity, but simply it's a political matter. The senators don't like to do it, and certainly those on the other side, what I call the 435 would-be senators, they don't like to do it because they're not part of the process. So even those like Moynihan, who were strongly internationalist and in favor of international law and treaty ratification, evinced a very marked disinclination to change the law on the treaty now.
Let me add one thing to that, and I got Paul, Carlos, and Ed on the list, really. But so probably a lot of you are familiar with this, but maybe not everybody is. That if you remember when Congress passed the Religious Freedom Restoration Act and the court struck it down, right? There was actually a proposal floated. Well, you can basically reenact this under the treaty power. And my understanding is that the almost universal reaction among congressional staff was, that's just a non-starter. It's just not going to happen. It wasn't even they gave it serious consideration. It was just like, we're not going to do this. And I think it's exactly what you're talking about. Paul, you were...
Well, partly I would just restate what's already been said, and I'll throw out a this relation to the Supreme Court in response to David's challenge. I think there are multiple ways of thinking about constitutional law, only one of which is a set of rules the courts enforce. And I think in many ways that's the least interesting aspect of constitutional law, especially with the poverty of talent on the court for those enforcing. But it's also a nexus of policies, thinking about problems. And in that sense, I think very much like international law. Is Missouri and Holland good law? Well, I actually think it was partially overruled by Regan Covert. Although you can live with the two, but I think that the logical implications of one are that we have a set of concerns that trump the treaty power, and one might believe that federalism concerns are another. One might believe that it's a locus of liberty versus what preserving. One doesn't have to believe that. One doesn't have to tie that belief to any founding understanding. And I wouldn't be surprised if at least the Gang of Four, no one Kennedy would do, but at least the Gang of Four would be sympathetic to Kirk Bradley's arguments, even though they're not necessarily solid originalist positions.
I think my comment is maybe in a slightly different direction than Paul, is to insist on a distinction between is it a good law question and is there a political will to exercise the power question. I think what we're seeing prior speakers have noted, is that there's no inclination to use the power that Missouri grants the federal government, and that's fine. There's no obligation to pass laws that are within congressional powers to pass if there's no will to pass them. In fact, I think it's already been mentioned, but I think I perceive the sort of opportunistic uses of non-Missouri Holland, but the opposite, the claim that there are constitutional limits to disguise political disinclinations to pass laws. I mean, another example was during the 50s, the OAS Private International Law Convention, the United States would simply say we don't have the power to ratify those agreements. It's left to the state within our system. And in this situation, nobody brought up Missouri Holland, and the discussion was ended. I'm sure the United States legislators were aware of Missouri Holland. And perhaps they thought about it as well. I will say, though, that I think the question is relevant to a very narrow sphere. As we discussed yesterday, it's only relevant to the extent there are limits on the legislative power under Article 1, Section 8. And in fact, with respect to the Private International Law Convention, another reason why it seems opportunistic to rely on this principle is that probably those conventions were followed within Article 1, Section 8 as construed in 1915.
Well, our second question is only relevant to that extent. The first question is sort of treaty power and relevant.
Well, but it's the same test. There was something to question the test.
Well, right, but if you thought, if the Supreme Court was going to overrule only the second question, that would only, it's only the second question, that would matter only to the extent that there's limited integrated powers. If it were overruled Missouri Holland as to the first question, that would matter as to perhaps a whole host of things.
Yeah.
Right.
Well, to add to the reasons why the second question at least is a little bit important, not only the racist apparent limitation of Lopez and Morrison, but also the availability of other constitutional powers. In fact, the idea that the treaty power would be used to circumvent limitations of Article 1, Section 8 seems strange, in addition because there are so many other easier ways to circumvent Article 1, Section 8, including the spending balance. You might object to the spending power.
I'm just going to ask for a quick, on this question of opportunistic uses. Sort of implicitly, my non-lawyer hat when I was in the Foreign Service, it was a good defense in the cocktail circuit, but also when I was serving Berlin, we were subject to daily protests on behalf of India Abu Jamal, and I used the Governor Ridge defense. You shouldn't be protesting on the American embassy, you should be protesting the Governor Ridge. I can't do anything about the fate of India Abu Jamal. So implicitly running out using federalism as a mask for black and fluffy girls.
That was in Pennsylvania.
Yes, he was governor of Pennsylvania at the time.
Right, Ed, you go next.
Well, first of all, to be somewhat redundant, I really think the significance of this does attach outside courts for the most part. Two regards. One, I think that it really does affect potentially the scope of perceived executive branch license and working negotiations and holding discussions and checks. Certain moves that might be made with the internal dialogue between the executive branches with what applies properly purview of the national government's authority. And to a certain extent, we're overlooking one aspect of Missouri versus Holland, which is the check on the 10th Amendment. I mean, it's not simply about the scope of Article 1. It's not simply about the scope of treaty power. It's also basically running roughshod over a perceived obstacle to that, the physical radiations. And I think it's pretty important as a check on that move within, at least within the United States, discourse of political actors, that's of course. Also, as Producer mentioned, I do think it is relevant. I've heard several anecdotes to reflect that. It comes up in international discussions, and it meets the potential excuse that the U.S. has for seeking a reservation or refusing or trying to negotiate a clause down. I think looking beyond Missouri itself, I think it's an interesting symbol for the false promise of apparent authority. I mean, here you have what would seem to be a sort of the ideal from the standpoint of the national government. Okay, here's a power, you can use it. It's absolutely not limited in any regard, except you have to get some schmo overseas to agree to it, and then you can basically do anything you want. And yet, look at how underwhelming it is, right? It has never fulfilled that function, ever. And whenever it has looks like there's a margin between it and the other powers of the national government, it's been questioned, it's been subject to amendments, and so it really just shows, whether it's the genius or the failure of our political system, I don't know. It really shows that concerns about unchecked government are running riot with power that are really disappointing.
Yeah, I guess my concern related to that, I think the unchecked government is simply run riot using other powers. I think it's very significant that Missouri, just 15 or 20 years after Missouri versus Holland, you had the New Deal revolution on limitations on federal power. And then for some 60 years after that, it was pretty much assumed that anything Congress really wanted to do, it could be under commerce power or spending power or some combination of both. And even, after Rachel Lopez, a little bit of limitation, but even that then was kind of blown up by, after Lopez Morris, there was some limitation that was kind of blown up by Rich, and even to begin with, constrained only modestly. At the same time, the treaty power is also an important point that Carlos Vasquez made, that you have to get 2/3 of the Senate. And that actually, I think, is a very significant constraint. So it means you have to have a pretty broad bipartisan consensus to circumvent federalism that way. And if the consensus is that broad, you can just enact ordinary legislation through Congress and get it that way. So I think it might potentially still be significant if the court does in the future reimpose significant federalism limitations on the commerce power, spending power, perhaps both. Even then, it won't be easy to have circumvention as a 2/3 requirement, but you might be able to get it through wide rolling in the Senate or something. And obviously also, there's the additional, to my mind, danger to other people, opportunity that if the court reimposes real federalism limits, Congress could try to use already existing treaties that Carlos refers to as vague and aspirational. They could say, but we have the ICCPR, we can enact legislation under this, and there should be a rational basis review, say, for whether it's truly connected to the ICCPR or not. And the courts may or may not accept arguments of that type, but in that world where there are real federalism limits, there could be some effort to exploit existing treaties with broad language as a justification for legislation. But so long as you have Raich, so long as you have South Dakota versus Dole and other similar precedents, the motivation to do these sorts of things will be relatively small. Academics will feel it, but actual policymakers will be like, I don't really care what constitutional authority I cite for my bill, as long as I can get the bill passed and it won't be struck down. And so the easy thing to do is just cite the Commerce Clause.
Now, I completely agree with the proposition that the treaty power makes this special, right? And I also agree, and I like, because it makes whatever I've done in the past somewhat more relevant, I like the idea that this is significant in some regard. But empirically, just as empirical, putting aside the potential, right, it's never worked. Right? It has never provided that cover. I mean, in a way, it's never allowed. We point to a circumstance in which it has enabled a significant treaty to be adopted and implemented within the United States that was not going to be acceptable under the construction of domestic law.
Interstate crimes under the 10 terrorism, not the post 9/11 ones, because there you created federalism, either federalism limits or allowed the existing state law to serve as argument. But like the hostage taking convention and the other kind of part of the dirty federal, there the federal legislation criminalizes all acts, including acts that arguably within the intra-state. So if you had a hostage taking.
Do you think those would not have been sustained under the prevailing Commerce Clause? Okay.
I think that's like the one. I mean, I think that is cited as one example. The road traffic conventions often cited. I guess my thing is, I think it's not a consistent story. I think that either side trying to tell a consistent story comes up with counterexamples. And so I guess my thing is, I kind of just see it as a more of a dialogue than a one side is always been right on it.
Well, if you go back to Bobby's question, certainly the sort of late 18th, early 19th century, you had treaties regulating property rights, treaties regulating debtor-creditor relations, which I don't think any other federal power would have allowed the federal government to do.
I completely agree. I think pre-Missouri versus Holland, there was, so the question is in part what we do Missouri versus Holland before getting into right?
Right.
But I agree, pre-Missouri versus Holland, there did seem to be this continuity structure. I just haven't seen it, or I can't think of an example.
I got Mike next.
Well, I wanted to look a little bit beyond that final question of whether the Missouri versus Holland is right or something involved, and talk about what I see as the significance of doctrinal discussions from what characterizes them sort of the broader sense of ideas. I think that entirely beyond the question of whether Missouri versus Holland is right or wrong, that talking about it puts federalism on the table and attunes us to federalist values in a way that if you just dismiss it with the back of your hand, you don't think about federalism in a serious way. Just as I think with respect to Lopez and Morrison, I don't think those cases in themselves are particularly significant on the grounds on which to be passed the Defense and School State Act. But that's not really the point of those cases, I think. What those cases were is they signaled that we should think about this stuff. And when we then sit around and think about it the way that we have in this, using the Missouri versus Holland as a jumping off point to think about federalism, I think that's the great significance of it. And so for someone like me that takes a broad view of Missouri versus Holland, but is still very concerned about federal values, I think talking about is very important. And so I guess that's my pitch for doctrinalism, with a value beyond just the doctrine itself. But we're, to some extent, we are some of the leaders in the intellectual area, religious intellectual area, and when we think about it, perhaps that matters regardless of whether the case itself matters. And just on a final note, Julie and I were talking about after the conference yesterday, how not so very many years ago, in talking about foreign affairs federalism, we kind of felt like pioneers. And now we have a conference about foreign affairs federalism, keyed off Missouri versus Holland, where some of the sounding things, to my mind, are said about the value of the states and foreign affairs. So I think it's that kind of a shift in ideas that can come out of with that kind of discussions and something relevant beyond the case itself.
Duncan, I had you next, but I don't know if you already got in. No. I had you on my list.
I already interviewed.
All right. Julian, you're next.
Okay, yeah, I just actually sort of to follow up a little bit on that. The one other set of institutional actors we talk about the executives of the Holland are the state governments themselves. So we talk about the executive branch, we talk about the Senate, and we even talk about foreign countries. But actually, you would think that the people who actually would pay attention to the state governments, of course we know that we might assume they don't, but actually I wonder if you could draw some line between increased activity among states that a number of people have either documented or celebrated in foreign affairs, in engaging in perhaps unconstitutional agreements with foreign countries or exploring sub-regional compacts or whatever, whether this can be at least the questioning of Missouri law, or the sense that it's kind of brought out, old or forgotten, or needs to be partially overruled, has sort of been part of the reason why states have been more active and more willing to be active in the international stage. And that I wouldn't buy into claim that it has been a driving force, but the way I conceptualize it, it clears out the tiniest bit of constitutional space for the states to then step forward and feel more comfortable. It also perhaps puts some additional political constraints on the federal government and changes the ethos. And I think that is an interesting phenomenon to document, whether that's part of what is really going on here. Our conversation, I don't know if the leaders, but within what think about this case, is important, and it sort of leads into this larger sense among state governments. Hey, this is something we can be a part of, and we should be a part of the international conversation.
So, as I just the micro, and then several points on the way. I thought that in terms of sort of thinking about the utility of Congress in Missouri, independent of direct jurisprudential doctrinal sort of significance. In some sense, lots of our discussion yesterday and a number of remarks today got me thinking that it's a useful vehicle for us to engage in a kind of micro-analysis of the political dynamics of federalism. Right? So Julie's last comment about sort of how the states speak to it, and then Duncan's comment about how they go back to the United States, foreign negotiators go back to the United States, and then again, domestically, this question of, within this particular dynamic of Holland versus Missouri, what's the nature of the congressional dynamic? Carl's going to talk a little about after the panel. What's the story of, what's the relative efficacy or valence of supermajority requirement in the Senate versus bicameralism and presentment as vehicles for the political protections of federalism in this particular context of Holland versus Missouri. And that's does Holland versus Missouri create an opportunity to engage in this kind of close analysis, micro-analysis of those political dynamics, questions of political dynamics of federalism.
I got Paul, then David, then Nick, and then Nick.
First, a technical point about we can question what a precedent means, but arguably the premise of the case has been overruled, and the conclusion the case reaches also is problematic. And I think the premise of Missouri and Holland, that wildlife is intrinsically state rather than anything else, was definitively overruled in Oklahoma versus Hughes, which I just remember because it came up my term, and everyone was thrilled with the case about minnows. I'm trying to suggest something broader, though, which is it's possible to just view Missouri and Holland as a way station and the lingering death of dual federalism as a concept, and that the rise and fall of dual federalism in the Constitution really didn't have much to do with original understanding. It reflected fundamental problems that were being dealt with at the time. And in today's conditions, the structure of the economy is one where it's just impossible to build in the federal state in so many areas. Things are so interpenetrated, that whether we're talking about commercial activities, personal activities, family life, and so something that insists on a categorical distinction just is bound not to work.
Okay, I'm going to raise a point with some trepidation because it's very non-normative and non-doctrinal. In a way, I feel a little bit like a country cousin coming into a rather esoteric discussion. But the point is this. The treaty ratification process, in my particular experience, is highly political, and it's born of perceptions. Julian is exactly right. In the area of private international law, the states have come to understand, the state representatives in the understated English are here because he's a uniform law commissioner and knows this process well. They've, in the last 8 years, become very, very aware of what's going on in the area of treaty ratification, private international law. And their visceral instinct is, of course, to claim that function, or at least a strong role in participating in the treaty process, both the negotiating and the implementing. And they know that from Missouri v. Holland. So that And they're very happy that the government isn't relying on it, but is as an open door to participate. But that's a powerful political fact. And when I look at, for example, something like the Choice of Court Convention, while there are very strong jurisprudential academic support for saying we could ratify that treaty on the basis of Missouri v. Holland, and in fact, Linda Silverman and Andy Lowenfeld have done a draft statute that would do something like that. The countervailing political concept is that if we were to take something like that to the Senate, we have a very powerful voice on the other side that would change the complexity. The other point is even a little bit more sensitive. Peter has reminded me. In fact, it depends entirely on who's making the pitch. In the context of the human rights treaties, it wasn't the government that was promoting the use or reliance on Missouri v. Holland. It was, to a great extent, the NGOs. And I can think and give you examples both from ICCPR, the Women's Convention, the Race Convention, Rights of the Child Convention. It was the advocates who very explicitly were going and saying, we would like to accomplish under the treaty power that which we have tried and failed to do through the ordinary legislative process, both at the federal government and in the state government. And that pitch got nowhere at the Senate and elsewhere. It was precisely the advocates who were trying to change the law through the treaty power who it wasn't the government, it was the others. So that's part of the mix. The last point is with regard to foreign officials. I have a somewhat different experience than Duncan, and I suppose it's totally personal, but in many cases, the people on the other side have been trained by you folks. So your LLMs and JDs go on work in foreign ministries, and so they're perfectly happy citing Missouri v. Holland. But at the end of the day, when we say X provision is problematic for us, they say we don't care. If the United States is going to ratify this treaty, then you're going to implement it. We're going to look to the federal government to take care of things. We don't care if Wisconsin opts out or Texas has a different rule. We want the assurance of the federal government. So my experience is it's not really a very powerful argument. It's a negotiating point. But at the end of the day, they say you're in or you're out. That's it. Even, Paul, when it comes to something like Reed v. Covert or the First Amendment, I can't tell you how many times I've been negotiating the First Amendment issue and saying we categorically cannot accept it, and they say that's your problem, we don't want to hear about it. Of course, the First Amendment, we're at the end of the line, the most aggressive, the most liberal. No other country has it, so we're always alone, we don't get support.
I guess I'll just say something that I think is quite obvious and implicit in what's been said. But so we've asked whether Missouri v. Holland is relevant in light of expansive Commerce Clause or an enumerated powers doctrine. You just as easily ask that the other way. You say, well, does Lopez and Morrison matter in light of Missouri v. Holland? Or do the 11th Amendment cases matter in light of Missouri v. Holland? Or does South Dakota v. Lowell matter? Do any of these cases matter in light of the fact that Missouri v. Holland says? When we reverse the question, ask it that way, I guess I'm wanting to suggest we have to think about all these cases together if we're interested in the idea of limited federal government. So if you think the federal government's power is, Missouri v. Holland stands for the proposition that Congress can get itself to infinite power via treaty. If it already has infinite power, that's not so interesting. But if you think it does not have infinite power, you have to confront Missouri v. Holland and also these other cases and figure out how to do that.
If I could just use moderator privilege for a moment, because I think it's an interesting way to think about it. And I was trying to think of the counterfactual in terms of this discussion of political power and how it's played out in terms of on-the-ground negotiations. The counterfactual is something like, what happens in 60 or 75 years when the United States is no longer a hegemonic power? How does that alter both our conceptions of sort of expansive federal powers that kind of coincide with the rise of our international power, but also the idea that Ed raises something of the danger of, well, we just go out and negotiate with some taxi, and then we can use that to expand federal power. But what if we're taxi? What if it's the other side that's using the treaties to, we need to get onto the treaty to extract some sort of benefits from a relationship that's normally the sort of negative side of the asymmetrical power relationship?
That's a great question, and it prompts a debate that Carlos and I are having, really. I asked the question, imagine the U.S. loses a war. and in the peace treaty, the other country demands some concession that violates the Bill of Rights. Reed v. Covert says a treaty cannot do that. A self-executing treaty, right? So imagine we lose to Canada, and Canada says, as a condition of peace, you can't have any op-eds in the newspapers that criticize Canada. Right? You can't. That treaty cannot be self-executing, says Reed v. Covert. The question that Carlos and I debate is, can that treaty be non-self-executing? You enter into a treaty which says, we promise that we will change our structure such that we won't have any op-eds criticizing Canada, and then it's essentially a promise to endeavor to amend the Constitution on that point. Would that treaty be constitutional? I wonder if anybody has any thoughts about that.
Two questions, just because one, the treaty might be void for coercion unless the war was legitimate. You could make an argument that the treaty was void and the international law treaty was absent unless it's going to have a UN action or self-defensive action. Right? So that right from the get-go, there'd be a question of whether the U.S. would have to comply with it at all. But I'm assuming that you're actually assuming that it's not about the legalities, but about the fact that we've lost the war and the foreign power will occupy or whatever. In which case, I think we're off in a different world. Japan could have looked and said, well, these are all violations of our Constitution. It doesn't really matter when we lost the war. The other thing, I just want to clarify. I think Reed v. Covert, when I agree that Reed v. Covert signals that treaties can't violate the Bill of Rights, but it's worth recalling that was not the question the court was asked. The court was asking whether an executive agreement could do so. And so there would be wiggle room, for example, if one wanted to get all doctrinal and would use Missouri for the opening that got Kurt and I think so worried is that even pre-Missouri there was this possibility of a Sutherland type argument, I suppose. It goes all the way.
Yeah, well, that actually ties into something that I was going to raise, which is, if we're going to worry about international law and federalism, shouldn't we be a whole lot more worried about Garamendi than we are about Missouri v. Holland? Because Garamendi basically, for two reasons. One is a whole lot more executive agreements than we do treaties, right? I mean, treaties are a very small proportion of the international agreements we do. Two is that there are no political safeguards for executive agreements. I mean, at least with treaties, you got sort of a 2/3 vote in the Senate you got to overcome, which is why nobody's using treaties to do what Missouri v. Holland, not in my view, one of the main reasons why nobody's using treaties to do what Missouri v. Holland says you do. But then we got, Garamendi saying, well, you don't need to get the 2/3 vote, just go out and cut the deal, and then it trumps state law anyway, right? So why isn't that much more of a problem than Missouri v. Holland?
Well, I'll say this. And just to make a further pitch on Garamendi, it's implicit in what you're saying is that it actually requires an executive agreement to get a Garamendi effect. My reading of Garamendi is that that's not the case, and although I would prefer it to be read the other way, but in fact, the actual result of Garamendi overrode state law as applied to companies that were not covered by the executive agreements. So there's already a little bit of a wedge beyond the executive agreement. And then if you look at the executive's argument in Medi, which there's still a treaty, but the executive's argument did not necessarily rely on the existence of the treaty. The executive in Medi cites Garamendi for the proposition that executive foreign policy overrides the states.
David, you will welcome it when maybe comes back on Garamendi.
I might have a mixed reaction, but that piece of it, yes, I will. Julia.
I guess sort of a couple of points on this issue of, well, what if the U.S. wasn't a hegemonic power? One is empirically, there are non-hegemonic nations like Canada and Switzerland that maintain tighter limits on federal power than the U.S. does. So straight limits on federal power and non-hegemony, I think, are perfectly compatible. I think also, the U.S. is not hegemonic 50 years from now, it still will be at least one of the 3 or 4 most powerful nations. So if we wanted to find a patsy in the sense of being much weaker than the U.S. to negotiate with, we could still maybe treaty with Guatemala or something, or El Salvador or whatever, to achieve those ends. If we lost the war and we're defeated, I'm under people like Abraham Lincoln who says that there might be instances where it's normally defensible to act in an unconstitutional way. So I think it might well be, if we were defeated, some horrible dictator said either you limit the ability to criticize me in your press, or I'm going to come in and kill like 500,000 people or something, then maybe you do it, and maybe even it would be normatively justifiable, but we don't have to say it would also be constitutional. We would say that this is an unconstitutional action, but which is nonetheless less bad than the available alternative. So, as Thomas Jefferson said, adherence to the Constitution is a very important value, but it's not the only important value, not always the most important. It's not an exact quote, but pretty similar to what he said in his letter on the Louisiana Purchase. And I think there's some value to saying that certain horrible things that might nonetheless be desirable, necessary to do, are still unconstitutional, and therefore, we do them, but they don't serve as a binding legal precedent or whatever. So that years after that censorship began, the U.S. government could not say, oh, well, because we censored as a result of that war, that made this constitutional, so we need to do some more censorship now. If it was widely understood as just a result of illegal coercion, then perhaps the damage would be at least somewhat limited.
Do you want to look at something? But let me just suggest this is not as radical a thought as it sounds. So the way a non-self-executing treaty works is we make a promise to exercise our Article 1 powers. Right? We promise that we will pass some legislation that does X. There's not a guarantee that we will actually do that, right? Then we will go to our House of Representatives and try to persuade them to do the thing that we promised to do. So we make an international legal commitment, and then we may exercise a constitutional power in order to fulfill that agreement. Now, is that so different, or is that qualitatively different from making a promise, international legal commitment, to exercise our Article 5 power? Now, we may or may not have the political will to do it. We have to persuade a different bunch of folks, just like we have to persuade the House in a non-self-executing treaty. And we may or may not succeed, and if we don't succeed, we'll be in breach of our international legal commitment. Why can't you make a promise to exercise Article 5 in just the same way you make a promise to exercise Article 1?
I think with Article 5, you're making promises on behalf of actors that are not part of the federal government. So it needs ratification by the states unless you're making a promise to, well, any of the three modes that are in Article 5, there are actors other than the federal government that would have to be involved, and therefore it's making a promise on behalf of others and not just on behalf of the federal government entity.
But even in Article 1, you're making promises on behalf of folks who are not treaty makers.
Yeah, that's true, but they're part of the same entity of the national government. So at the very least, those Article 5 people are further removed. Plus, as a matter of practical reality, any foreign government that knows how the Article 5 process works will probably assume that a promise to exercise Article 5 is kind of a dead letter, that the actual likelihood of an amendment passing is extremely low, whereas the likelihood of legislation passing through Congress, well, perhaps not easy, it's higher. So even if, for technical legal terms, when these are both just promises to exercise powers, and one power is almost impossible to actually exercise and the other one is not, then there will be a distinction between their two.
I just remember the 13th, 14th, 15th.
Yeah, but the states were coerced into ratifying.
That's the point.
Okay, so maybe the idea is that the federal government is expected to send an occupying army to force recalcitrant states to ratify, the Credit Instruments Convention or something, or whatever.
Let's I think Ed and Carlos and you for this.
Sorry.
No, I just want to sort of wrap up this sort of first part of the discussion because we started to lose people. We unfortunately lost one of the discussants for part 2 of this. So, Ed and Carlos.
No, this is on Nick's question about whether the debate that we're having I think we may disagree less, again, than you think. I mean, I think there's no problem with a treaty that says we promise to try to pass a constitutional amendment banning political speech. The treaty I'm thinking about is a treaty that says we will incarcerate people who make certain political statements. I think that treaty is unconstitutional, whereas, as I read your piece, you would say that is a constitutional promise to pass a constitutional amendment. And I think a treaty that agrees to do something to abide by a legal rule that is unconstitutional is simply an unconstitutional treaty, not a non-self-executing promise to pass the constitutional amendment.
I agree, but you think that a promise to amend the Constitution is not...
Yeah, for what that's worth. A promise to try to amend the Constitution is how you put it.
Okay, but
so everybody knows it's impossible to do, or very much likely to happen.
Okay, but Carlos, if you and I agree about that vis-a-vis covert and violations of the Bill of Rights, then why don't we agree about it vis-a-vis enumerated powers? So what I would say is a treaty that, in the Missouri Holland case, a treaty that extends beyond enumerated powers, merely a promise to amend the Constitution to give Congress the power to enact legislation.
No, it depends on what the treaty says. The treaty said we promise to try to get a constitutional amendment.
We're just going to try to pass such legislation. Now, if it is necessary to get a constitutional amendment in order to pass legislation, that'll be a necessary step, but it'll just put us in the box.
I just want to interject one thing here, which is, I'm skeptical whether there has ever been a treaty the U.S. has entered into that's framed the way you're framing what you think is a non-self-executing treaty. We never make promises to seek legislation to do X.
That's Missouri Holland.
We make promises to do X.
We will enact legislation to criminalize cybercrime along the lines of Article 5.
But it's almost always in terms of legislation if necessary, right? Because particularly with multilateral right, and that if necessary is there because it's recognizing that different states have different systems. Some need legislation to do it, some don't. But it's never framed that I know of in terms of it will be legislation. The promise is to enact legislation.
I think it's legislation if necessary in the sense that you may already have the legislation on the books, but if you don't have the legislation on the books, you have to pass the legislation.
No, because the if necessary recognizes that some systems you don't need legislation at all, right? And some systems you do, right? And it's sort of fudging the issue, but it's never framed as a commitment that we have to enact legislation.
Just on the constitutional question, I think that what's running up in my head is the practice, right? So what actually has happened. We've never had to, but certainly other countries, Europeans in particular, have entered into treaties that require them to amend the Constitution. What they don't do, they don't agree to the treaty and say, we'll amend the Constitution. They agree to the terms of the treaty, but then they don't bring the treaty, they don't ratify the treaty until after they've amended the Constitution. So I think that there may be some tension between the actual practice and your hypothetical. That seems to be how most states approach the issue, particularly because you have the British and the Canadians and the Israelis and the Australians out there, for whom that's their practice anyway, which is, we're going to enter the treaty, but you need to understand if it requires us to do anything domestically, we need to amend our law. And all of those states, their practice is not just to join the treaty and then say, oh, sorry, it doesn't have any domestic legal effect. They all have a practice of getting the legislation first and then joining the treaty if that's what's required. Now, that's their policy, that's their practice, there may be counterexamples, but at least that seems to be the general story.
Do you have any constitutions? Did they have constitutions or easier?
I mean, the treaties in the European Union are all examples of the European framework.
Right. Yeah. The ICC, I think several done it for the ICC as well.
Several maybe not for the ICC.
The trade treaties are a huge counterexample to that certainly. They're almost entirely promises to bring laws into effect.
I'm not sure that that's right still, but we can talk about this later.
But they're not our...
Should have matter, I think. That's true.
Do you need to move on to
No, well, you're the last one here for this discussion.
No, this one, well, okay, so just consider the following. So I'm emboldened by the counterfactual. This is much more of a mainstream counterfactual. But it's really basically the question underlying it. So what if right now Missouri were reversed? Right? What if Missouri versus Holland were reversed? It might be somewhat different if we said it would come out the other way at the time. But let's assume now it would reverse. What would happen? too broadly interstated foreign commerce in order to accommodate. I think the third thing is we might see considerable pressure, a la Garamendi, to find implied Article 1 powers. So we see the resurgence of kind of Curtis right kind of arguments. No, I'm saying like Garamendi finds these implied presidential authorities to the president to do things via foreign affairs that we don't think the president can do. I think similarly we find authority for the treaty makers and for on the question 2 that we identified yesterday. I think we see a lot of pressure to find applied authority to conclude international agreements, even though we wouldn't find cognate authority for purely domestic purposes. We see sort of first right type arguments on the globe. So the question is, better, first of all, do you agree with that prediction? And the second is, better or worse world? I think probably worse world. Even
we can do like a McLaughlin group. We just go, there's 2 questions. Do you agree or disagree, better or worse world? Yes or no?
Yes. So this is a derail, I'm sorry.
Does anyone want to respond? We could go around. Better or worse world, yes or no?
Well, it could be disagree with prediction, but...
I just pose a different counterfactual, which I think is maybe the opposite of the counterfactual that exists. But if we're going to consider counterfactuals, it's more productive in my view to imagine a world in which the Article 1, Section 8 power were not so broad, were more like pre-New Deal, and I think that would mean the issue would be more significant. But in my view, it also shows the rightness of Missouri versus Holland, at least the first holding, because under the pre-New Deal version of Article 1, Section 8, many things that were core things that treaties have always done, such as promise to treat the citizen of another state in a particular way with respect to education and religion. If Article 1 were a limit, those treaties would be invalid. So I think that counterfactual, again, it shows it makes the issue more important, but at the same time, it shows the whole thing.
And perhaps we'd see some sort of reliance on Carlos's define and punish theory. And a complete expansion of that, using the define and punish clause to basically implement everything that's going on in these universes based on compliance theory. Okay, this is going to be absolutely the last word, then we're moving on to the next topic.
Yeah, I think if you just take it in doctrinal isolation, it would make very little difference if there was just this one change or everything else up in place because our Article 1 is so broad. As a practical matter, I don't think the court would overrule Missouri versus Holland unless that were part of a broader counter-movement against the idea of unlimited federal power. And if it were part of that broader counter-movement, then to my mind, that would be a good thing for a wide variety of reasons that I've written about and some other scholars have written about. And so when you broadly, Missouri versus Holland is a very small part of this enormous trend that we saw in the 20th century, not just in the U.S. but elsewhere, of expanding the power of government to the utmost possible limits. In the late 20th century, beginning of the late 20th century, there's finally started to be at least somewhat of a movement to say, well, maybe that wasn't such a great idea, and maybe the costs of that are not worth the benefits. And it remains to be seen whether that counter movement will really make real progress in reversing, or whether it will simply be limited to blocking or reducing still further expansions of centralized government power. And that's sort of the broader trend in world history of which Missouri versus Holland, or debate over Missouri versus Holland, is a very small part.
Well, that's a good sort of transitional point to get back to the states, moving away from the national powers and returning to the second panel, in particular the discussion about John King's approach to the compact clause and some of the functional questions about whether we think courts should be involved at all in oversight of some of these local and state activities, federal courts. So I'm going to open it up to just sort of both the private international law side of the discussion and also the questions raised in John King's paper.
You can take Ed's counterfactuals as jumping off and put the answer that it wouldn't be necessarily a worse world because of all the developments that Paul and Duncan and Julian were talking about yesterday, and also Janet, I think, if you heard from the episode with Oklahoma, and that's a very instructive one. So you've got the states as part of the system now in a way that they can be disciplined, so that when there's trouble, when there's a need to get the states on board, there are now other mechanisms to deploy by way of getting them on board. So we're maybe one way of so it's unlikely, I think, that we're going to find ourselves in a situation where it's really important to get a state on board for something and it can't be done through some other channel than through the courts and reservists.
This was the argument I made in the Columbia piece, that basically to the extent that conservatives was compromised, there were limits, or there were, for example, also for purposes of transfer.
Now putting it on the web.
He's also not Julian Curella.
So the argument was that even if we had limits on Article 1, so I'm just, or anti-commandeering limits or something like this, we could envision the sort of aggressive use nationally or nationally initiated use of the compact power to basically enlist the necessary amount of states and do it that way.
Do you agree, Duncan?
It's an interesting question. I mean, if you're thinking about structurally, the notion of not being national, there's some scholars suggest that for the federal government to actually go out as opposed to the states or the compacts you're going to enter into with these European entities, or subnational actors, or that might. It raises interesting questions. I don't know if I have a specific view on it. But I mean, I guess from my own, at the end of the day, where I come out functionally is that this is a cooperative mechanism. And so, although I think it's too late for these to be largely been state-initiated, even state seeking autonomy on this one could envision if you actually get to where I'm supposed to go, which is to try and actually bring the feds and the states to table together. It could, certainly there's room for the possibility that the federal government could go to the states. If it wasn't otherwise available. I think partly one of the reasons the federal government likes Missouri and Holland, and even if they're reluctant to use it, is because it does provide immunity. One of our arguments for the Europeans is always, well, we'd really like to negotiate with the European Union, or we'd like to negotiate with the individual states. We really don't like to negotiate with both. It's brilliant for them because they can the negotiating dynamics are change dramatically. We're kind of negotiating simultaneously with two entities that have overlapping jurisdiction. And we've always made the joke, well, if you're going to play that game, overlapping competency, why don't we bring our 50 states to these international negotiations and we like 51 votes just like we get 26. So, but I think we start to head into a very different world if that starts to become available.
I'm not sure I'm following all this. Can I just put an example on the table to follow this up to see how it works? Let's take enforcement of judgments from overseas. Right now you have a situation where that's almost entirely a question of state law. There's some overlay by the Supreme Court, Hilton versus Gallo, but you have it regulated primarily by the states, to which a majority, but certainly not all of the states, have adopted a uniform law with some variations. So that's a complex mosaic. And the foreign states, we have a national interest in having some sort of uniform regime for the enforcement of foreign judgments because our system is more favorable to judgments brought here than ours are overseas. So it would be good in the large national sense to try to promote enforcement of our judgments overseas. So what are your options? You could do a statute straight up that says there now will be a federal statute on enforcement of foreign judgments. Question whether that's within the Commerce Clause or not. You can make the argument. Two, you could try to do a treaty, multilateral treaty that says these are the terms in which we will accept reciprocal obligations to recognize and enforce foreign judgments. That broad treaty collapsed, but you have the proposed federal statute, the ALI statute, which would federalize all this pursuant to the treaty power. Third, you have the idea which I'm currently pursuing, which is to have a minimal statute with perhaps a uniform state law, with kind of an opt-out. There's some precedents for that, in which the states actually get to reclaim portions of that pursuant to the treaty power. I guess fourth, you possibly may be suggesting a compact arrangement, a multi-compact arrangement, where the federal government would say, we encourage the states to do this. Here's the model arrangement that we'd like you to negotiate with, I don't know, Canada, Alberta, Tanzania, or whatever, and we'll have some sort of congressional executive commission to monitor this, but the states can do this pursuant to their constitutional authority, and here are the parameters, and we'd like you to use that. Now, one question is, why would any other country want to do that? Well, it's too onerous, and they would say, look, we're not going to deal with 50 states and however many subordinate jurisdictions. We'd like the federal government to do this for us, not to extend the time. Is that...
I guess, yeah, I mean, as you did, just to kind of, if I can quickly respond, and, something to say, I think the actual story is quite different in the international practices. So, I think Lydia was pointing, other countries had a tradition, and it's called the Canada Clause, right? So in the treaty negotiations, there used to be a clause that said, if you're a federal state and you don't have full competence over the matters covered in the subject of the treaty, you can join the treaty only for those subnational units that you designated.
Still in use.
Right. So it's gotten revived. It died for about 30 years. But what's interesting is that the number of states that use it, Australia went out and changed its treaty practice so that it could bring the states in line, as have Mexico and Russia and Germany now all have either constitutional or extra-constitutional deals in place with their sub-federal actors to avoid that very problem. I think Canada may be the last one standing, but even they now have backed off. And so so internationally, I think the opposite story. Rather than, at the same time we talk about disaggregation, you see the sovereign states have actually kind of grabbed hold a little bit more strongly. And it was the French largely who kind of led the countercharge, saying, what is the nation state but for? We need you to be able to agree for the whole state. So I just think it's a complicated story. I don't know that it's impossible, but it would require some interesting negotiations.
Yeah, well, so in my vision of this, we do not have 50 states in the negotiation. What we basically do is you either hammer out the treaty and have some basically ancillary compact, or you have straight out the gates a stipulated compact. You secure state assent to this by bribing them, or through use of the spending power, or you basically say if you don't sign on to this, you don't get the reciprocal benefits of the compact that you made with this foreign state, which may or may not be significant depending on the terms of the agreement. Right? Human rights, for example, may not be so great. Judgments could be greater. And so you then hammer this out. This becomes, with the assent of all the states you can muster, this becomes federal law under the prevailing compact laws. You get them on, it becomes enforceable, you can have it under those in all the ways you want, and it circumvents some of the federalism type concerns that we have, at least formally speaking. There's a way of pitching this doctrinally that overcomes it. You don't necessarily get total assent. It becomes a little bit like the GPA in practice, right? In which you have something that's been negotiated in a central way, and you've gone around and sort of routed your cup to 39 states or something like that ultimately acquiesce in this. This makes it more formalized, and it doesn't rely solely upon them stepping forward and volunteering or they're under threat. It makes it federal law.
First, in playing off of what I just said, there's yet another approach, which is to do it the way you do bond conventions. You put together a consortium, and you have voting rights within the consortium. You have a negotiating committee, you have a lead state, in this case, so California, New York, they're doing that. But that, and the immediate reaction is not the United States, isn't that unconstitutional? And my response to David's question is that I don't think that the choice among the array of alternatives ought to be seen as constitutionally constrained, except in the sense that the Constitution is a locus of policies and concerns that we're worried about, but not as an instrument that takes things off the table. And I would prefer the approach each in terms of which has the optimal political economy. And there's some situations where having, the states as stakeholders early on produces better events and keeps bad interest groups out and good interest groups in. Others where you want the national forum where the interest groups are best organized. But I don't think there's one size fits all.
Yeah, I was also going to bring up the family agreement, which, one question on that is, was there clear reciprocal interest for the states to sign on? Because that's what I read. And it's interesting because if you look at this from the perspective of the states, that in the changed landscape now relative to the time of Missouri versus Holland, is that there's now clear, in a lot of cases, there's a clear self-interest to come on board, and even when there's not, I guess, with a case like the Federalism, you still find them essentially. Is there an explanation for why 39 states did sign it?
I've talked to the people like Robert Schoenberg, is that his name, at Georgetown, was very aggressive. He basically thinks that it was a matter of the governors selling out their states. He's got some story about that, but I think it was perceived that it would be helpful to the state, and that it would help them as well in promoting the interests of their suppliers overseas, but it was very loose. I don't think that there's no formal reciprocity that I can comprehend of the case to get there, and I think there's been some regret. I'm not sure.
Well, maybe we can turn to sort of the question of multiple layers of governance and the third panel from yesterday about contestation between layers of governance, use of legal pluralism as a way of mapping what's going on in global legal order. And so my concern / question I'm grappling with, what does this all tell us about international law as we know it, so more specifically things like institutions like the ICJ and Federalism. So should internationalists be worried?
I certainly don't think so. I think first of all, it means that you don't have to constantly be battling about whether international law is law or not, because that becomes a debate that's irrelevant or divided, because the question has to do with efficacy, the legitimacy that's gained through on-the-ground practice and changes in legal consciousness, rather than through formal definitions. So from that point of view, I think the benefit for international law people. And it also doesn't prevent you from arguing for universalism, for universals when you choose to argue for them, or that universal priorities should be paid attention to when that's one of your commitments. So I don't see it as something that sort of prevents or constrains an international institution from making those arguments, etc. What it does do is it means, and I was talking with Ed a little bit about this after the panel, it means that when, for example, you're designing an international organization or some new institution, like, say, the ICC or something like that, it means that you might do things like create a complementarity regime. Not even so much as a political compromise, though that might be something that obviously is part of the politics of it, but as a theoretical benefit, as sort of an ideal, that you might say that would be a good way to organize something because it would activate a dialogue, it might galvanize local actors to do the kinds of internalization of human rights norms that you might like, and so forth, rather than just imposing it through a hierarchical relationship.
hybrid court rather than purely international court, and there might be advantages. It makes you think along those lines. I don't think it necessarily means that you have to weaken some of your core commitments, though it recognizes that not everyone can share your opinion.
But it sounds to me, if I should just sort of respond briefly, that the universal just becomes one of another set of preferences that arguably is these hybrid spaces and plural spaces. The idea that the universal is privileged is lost. Right?
I don't know what that means, but if you say the universal is privileged, that means it is?
Well, you said yesterday, Paul, that sort of there's nothing external. And I think that sort of as please that does, the universal is external to the construct.
Well, what does that mean? To say certain, if you say certain things are just universally true, I mean, you can go into sort of relativism of truth thing, but if you just say certain things just universally are human rights, and that just is true, then what if somebody else says, no, I disagree with you? I mean, if you're saying it doesn't suddenly mean it gets activated throughout the whole world.
Well, some would believe that, in fact, the Universal Declaration of Human Rights, establishing this sense of an international community reflecting the sense of universal norms, as a place in a hierarchy above certain other
Some people believe that, and I would agree that it's an important document and has had tremendous real-world impact on the ground, even among people who've never read it, because it seeped into the way lots of people think about the world.
But to sort of radicalize my position, I'd say, to your view, the Universal Declaration of Human Rights and the Nuremberg, the Nazi Nuremberg Declaration are just similarly a set of preferences that we can test in different hybrid spaces. And I think that approach, I'm becoming more convinced of the threat of that approach to the idea of universality, particularly in the human rights context. There's lots of context against all of that.
Very briefly to clarify, I think what you're discussing is the principle of an absolute, not a universal. Right? That's what you think is the state.
Actually, well,
no, I mean...
This sort of non-derogable...
Yeah, right. I mean, so it's the conclusiveness of it. It doesn't necessarily depend upon universality.
I'm not sure it's the absolute. I mean, I think what's going on is that you're talking about there's got to be a hierarchy, and you're opposing a hierarchy, right?
It's not that it's not even that I'm opposing a hierarchy. It's just it doesn't exist.
Okay, so
It
you're
just as an
saying
empirical matter. It's like the Supreme Court says something. That doesn't mean that is the way the world is. That just means the Supreme Court said something.
Okay, let me just clarify. I'm trying to speak the same language, which is to say there is a community of interest. That community happens to be the international community, which reflects its preference for a set of rights. We talk about whether they're absolute or not. It's sort of not relevant discussion of their universal nature. And the Universal Declaration of Human Rights, one of the most important aspects of it, to my mind, is the universal nature of it. That it's, and we can talk about some of the rights that are listed and whether they're absolute rights and their ability. That to me is a separate conversation. So it's within this discussion about communities and how these communities come together and contest these norms and borders. That if the claim of universality of the international human rights system is just like the claim of Aryan superiority, or the claim that women don't have equal rights under Sharia law, that to me is problematic to the project of international human rights. You may not support that. I'm just giving a sort of normative claim about the project of international human rights.
I know Holland was
Dan's logical question.
Sorry, Bobby was first.
Let me so the question is international sport. First, let me start. I want to get two answers. The first, no, and the second, yes. So start with the no, but from a different vantage than Paul. Paul made the point earlier about sort of the political economy. And the political economy, I would sort of describe the broader concept as sort of a question of comparative institutionalism. Right? So one could tell a story, which in this I think sort of is divergent from Paul's characterizing it, that we might embrace pluralism, interstanding governance, horizontal federalism, whatever the construct is, in certain contexts where the relevant sort of interest group dynamic, the relevant political economy is in some ways more suited to that. We consider, from whatever normative vantage point, more appropriately suited to that. So we could, as I said to Becky last night, one could construct a notion in which international human rights, or perhaps some subset of international human rights, is in some sense privileged in a way. The political economy, the comparative institutional analysis is such that we place it outside the realm of sort of a pluralistic, intersystemic governance, horizontal federalism framework. Paul's unsympathetic to that, I think. I'm more sympathetic, and that's where sort of that would be my version of no, there's no need to worry, because we may well construct a regime in which certain areas are set off and certain areas are seen as well suited. To Paul's discussion yesterday, again,
People will resist that regime.
People will create it. People will resist that. I mean, but we might nonetheless sort of be willing to not, I guess, maybe subject the regime to the same tit-for-tat, back-and-forth contestation, right? So we might privilege some things in terms of the degree of contestation. So that would be the no answer. The yes answer, on the other hand, again, I also played the theory last night, is that it seems to me what's distressing. There's two dimensions of what's distressing about the patterns, again, I think that Judith described, that I described, what Paul described, from a legal vantage in some sense. One is as to means and one is as to ends. As to means, it's a story of a fair amount of complexity, right? In other words, it's not one, it involves lots of moving parts. And sort of in some sense, again, as I mentioned in response to Peter, it seems to me Holland versus Missouri can be understood as the attempt to we want to tell a very simple, straightforward story. Right? The treaty clause allows the federal government to do this, and therefore they can do it, and whatnot. So as to means, pluralism, intersystem governance, horizontal federalism tells a story about complexity. And again, all of Judith's examples yesterday in her talk reveal that. This incredibly complex, dense array of interactions and patterns of networks and so on and so forth. As to ends, meanwhile, and I think this is the part that sort of I think Peggy is highlighting, the sort of story of pluralism, intersystem governance, so on and so forth, is a story of uncertainty. Right? So as to means, it's a story of complexity. As to ends, it's a story of uncertainty. It's hard to tell at least coherent story of pluralism, intersystem governance, or horizontal federalism that says you will achieve normatively desirable results. Right? So Judith's point, remember, at the very end of her presentation was to say, for all the sort of the embrace that even her sort of largely positive account sort of suggests of that there's utility to this, she acknowledges that these translocal networks may well be vehicles and have historically on occasion been vehicles for ends that we might perceive as normatively undesirable. So in that sense, that's the yes answer. There is a reason to worry in that sort of as to ends. I think we have to acknowledge that sort of if in fact or where these patterns of pluralism, intersystem governance hold sway, it's much harder to tell a story about here's the project. The way you described several times now is international law's project or normative project. It's much harder to talk about a normative project that intersystemic governance or pluralism or horizontal federalism will in fact consistently advance or support.
The bodies actually link together my points. I would say in response to Peggy that something for you is the legal fragmentation topic. Marty Costantini has this thing going in the ILC that is really about seeking to re-privilege use codes based on the kind of universality. And us critics would say, well, what he's doing is once again revealing that there is a European social democratic universalism, and there's American universalism, and that there are lots of universalisms, but there's no single universalism. And then the issue becomes, is this liberating because it allows us more effectively to understand the consequences of what we're doing and to seek the good more rationally? Or does this mystification of the kind of universality desirable? And that sort of cycles back to the point that Bob was making. I mean, I was pushing him last night about instance of intersystemic governance is extremely familiar to either of us, namely the tragedy of the anti-commons that was Russia in the early 90s, where they had all the systemic governance you wanted, actually. And the question that maybe wasn't entirely expressed is there a normative agenda can there not be a conflict? I'm not saying, I'm really skeptical of the idea that we can simply tell a story, that we are simply describing what's going on. It seems to me we choose what stories to tell when making long-term choices. So that I'm sort of resisting the idea that all we're doing is reporting that this is going on, because we're making judgments too.
If I could respond to you very briefly. No, I don't disagree at that level. I think you're right.
But it's a process-based normative
Right.
judgment. It has to do with the importance of having places of contestation, of political dialogue, of institutional interaction,
In and of itself.
deference, that those kinds of things in and of themselves will lead to certain values being promoted that are good, but they're process values more than they are endless values.
If I could maybe interject, just, because we had this conversation last night, and as I was sort of thinking about it later in sort of political terms, it's the difference between those who say we need to talk more with our enemies and those who say, no, we need to confront our enemies. This sort of idea of process, it's all good so long as we're all talking. I think I'm sharing Paul Stevens' concerns about there's a lot of normative stuff going on there, a lot of which everyone in this room, regardless of what we think about constitutional doctrinal commitments, what we think about our theory, would be not happy with.
Well, look, there's a limit to what law or any political structure is going to do for, if somebody wants to, go to war or bomb clinics or whatever, there are things that law is going to be unable to do. But I think that, I rely to some degree on Chantal Mouffe's idea of turning enemies into adversaries. And that's a different stance, so that people who are both pro-choice and anti-choice in the United States doing sort of constitutional and political contestation are adversaries, but they're adversaries within a shared social space.
If I could just
People outside of that bombing clinics are enemies and are not within the same social space. And that you want to try to create a context where as many people as possible are within the same symbolic space, but that's not going to be fully successful. And if there are people who are not part of that, nothing that I say or nothing that any of this says is going to prevent you or disable you from resisting that with every fiber of your being if you want to.
I just wanted to say that the insight, long before Chantal Mouffe, was that of Curtis LeMay, who, when he was being briefed on Soviet bombing plans, and being told about the Soviet as the enemy, he said, "Young man," to the captain that was briefing, "the Soviet Union is our adversary, the Navy is our enemy."
All right, I've got Ed, Mike, Duncan, and William.
Actually kicked down to the bottom.
All right, Mike?
I was trying to say is I'm a little bit of an outsider both to this kind of scholarship, which I think this scholarship has created turning onto, and also to some extent to international law itself. But I guess as an outsider, my reaction to your question is that in the short term, it seems like it is but in the long term, not, because competition is good. And I think one problem, again, is a little bit of an outside of international law, but instructive about international law, is exactly the assertion of hierarchy and the assertion of universality in the face of plain facts on the ground that the hierarchy is not really recognized and universality is not really universal. But the international law has relied on sort of its status as a trump card rather than relied on trying to truly get acceptance of merits. I think this goes a little bit to some of the stuff that Curators was talking against as well. The idea that it's actually, at least the way I would spin it, is not hostile to international law, but rather to say that it's good for international law for it to saying, well, we're international law, therefore we win. But by saying we win because we conclude that,
It's no more legitimate, but it's still less legitimate either, so it actually benefits international law on balance.
well, and I think it's a way then that international law, if it's competing in that arena, to refute some of the stronger critiques of international law that it's essentially being made up and imposed in the cram-down process. And so I think in the long run, this is something that international law should embrace because we're going to be stronger.
Stephanie?
I guess two things, and looping back to your original question. I mean, I guess when I think about this, the pluralist project, and the question of is it harmful to internationalism, I guess it's whose internationalism are you talking about? Because I mean, particularly for us dualists, right, or those of us who live in a dualist system and we're comfortable with the idea of overlapping jurisdictions, I think the next step in pluralism is more visible. But I think it's important to remember that a lot of the systems that exist are monist, and they presuppose a unitary system. And so the Dutch or the Swiss, they would regard pluralism as a threat to what they see as the goal of the law, which is to unify and to
Although they're getting used to it because they are.
Right, that may be true. But I think to the extent that you want to translate to the international level, I think on the one hand you have the ICC complementarity on the like, the other hand you have the ICJ and Guillaume as the president going out and saying fragmentation is a threat to the project of international law. What we need is hierarchy. What we need is a normative set of hierarchy and a process set of hierarchy, like an ordering. And Marty Crispiniani kind of doesn't believe in the courts needing to have a hierarchy, but does see this as a normative hierarchy. I think others, yes. So, and then Joel Chapman and others kind of reacted. Jonathan Cherney, before he died, actually himself, I think, very sympathetically. So there is a contestation within international law, but I think there's certainly a group of the international law project that would say, no, that is affirmatively, we don't want pluralism, we want monism. And I think one of the explanations they might give, and I'd be interested in hearing your reaction, is they tend to be the sorts of folks who like HLA hard and are still concerned about Hard's statement that international law is not a system but a set of rules. And so for them, I would say the answer is maybe we get to pluralism after we get to a system. We're not yet in a system of international law. Until we have a system, how can we have intersystemic governance? And so they're still worried about, do we even have a coherent system to communicate to other systems?
This sort of goes back to the Russia example, which is that there is an argument that that a more loose pluralist system only works against the background of some strong state or entity, so that it doesn't fall only into chaos. Right? So, warlords are a pluralist system also in a sense.
Somalia would be
So I guess extrapolated that would be an argument. We need to have the institutions of international law given more hierarchical valence before we can acknowledge that there should be other stuff going on. But in the international law context, I just see that as, in some ways, as a sort of a pointless positivist project.
I wasn't answering the question. I was answering the question of, do we see?
I have these debates. I've actually talked to Castellani about it as well. Many of these sort of European international law triumphalists are so into the doctrine of international law that they treat it as part of the positivist project, and it sort of seems divorced from reality.
They're emboldened by the European
But
success.
it's very interesting in Europe. I mean, there's now basically re-established doctrine. You've got a hierarchy, right? That the European law takes precedence over the national law, and so in some ways they've got their they've got their system in Europe, right?
That's right.
Whether they can continue or not.
Can it go in the opposite direction? Can you have pluralism and kind of competition, which ends up building a strong
Absolutely.
system?
In fact, I think, arguably, that's actually what's happened with international law from 1945 to now, is that
it's gained a kind of prestige, valence, importance, etc., by convincing people over time, by embedding itself into the consciousness of populaces and policymakers, so that, at the State Department, when a decision about whether to do X comes into play, we care, the international human rights has a seat at the table, which it wouldn't have had in the previous era. And so that, is a huge success, it seems to me. And I don't think that you have to say that it's, universally true to say that this is a value that should be, paid attention to in every situation.
Yeah, I guess sort of 2 points. One is whether it's a firearm, of course, depends on what your conception of international law is, and you don't really see this conception of too much at this conference, but as an outsider to international law, I was at a conference a couple months ago where it was mostly European international law scholars, and many of them, and most of them, do in fact believe that there's a hierarchy of international laws at the top, and not only is that at the top in a sort of legalistic, positivistic sense, but it's at the top in a normative sense. So it's good, right? So you have this view, well, international law is good, and the more international law, the better, and other kinds of laws should yield to it. I'm slightly exaggerating, but frankly, not by much. And many have also become very unhappy or hostile, even if you suggest, well, no, there might be some problems with this. So that kind of sort of Lord of the Rings approach of one ring to rule them all, that is threatened by a conception of pluralism, at least a conception which says that this pluralism is normatively desirable rather than merely existing in a positive sense, but as an obstacle to be overcome. The other thing is I would make a distinction between universalism and international law advocacy, because I think it's an open question whether universal values are best served by having one unitary international law rule over a wide range of areas, or whether in fact it's best served through decentralization and pluralism. And my paper is to some extent an example of taking the opposite tack, in that on the one hand you favor one sort of universalistic rule of free exit and to some extent free entry rights, but on the other hand it works precisely because many other issue areas would be left outside the scope of international law, and the argument is that better outcomes would be had through free movement and competition than through a group of international law elites getting together and saying, well, we think that this should be the labor rights policy or the human rights policy or whatever, whatever else. And I think that part of the mistake of this broader national law project is to assume that belief in universal values implies belief in one central authority creating international law from on high. And I think that a still greater part of this debate of whether national governments should have unlimited power is a debate over whether international law should have unlimited power. And I think many of the same objections that I have made in a domestic sphere to claims of unlimited power of national governments can be made in the, not just I, but also the other scholars can be made in the international sphere, but with even greater force, because as John McGinnis found in the article that Michael mentioned, much of the international law is generated in a highly undemocratic manner, whereas at least with the U.S. federal government, with something like the New Deal, although I criticize it, at least there is some democratic accountability there, whereas with much of the generation of international law, there often isn't.
Let me just do a little housekeeping, just because we started...
Sorry, I didn't mean to go on so long.
No, it's okay. We started 15 minutes late, so it's just coming on 10 o'clock. We go until 10:15. I think everyone who's still at the table is okay with that. Left it? Okay. Then you have the right for a last comment. I actually, while Mike is still here, I appreciate your appreciation of the dialogue, and before you leave, I did invite the positivists. The PPP, I'm going to call them now, the point was a positivist project. Oh, well, yes.
I'm going for positivism.
The European positivism. But I think this we've sort of gone off on a tangent, but the dialogue between sort of the foreign affairs constitutionalists, I will call them, and those who aren't, that are interested in federalism, or interested in all of these various other approaches to fragmentation and role multiple systems and so on. It has been really helpful, and I wanted to thank you and all who left already for So, but we'll continue to talk about you after the conference.
Thank you for getting us all together. It's great to see everyone. I have to run, so I got to.
I'm actually going to make a very quick comment.
Ed has been waiting for a little while, so you'll get Ed and then Paul and then Bob with us tonight.
Okay, so let me continue to play the hardline person here. First of all, there's just one comment that I made yesterday that I probably said, Paul, you said in no sense, which is probably accurate.
He didn't say that, he said he didn't understand it.
I not possibly
Not saying.
I'm a pluralist.
No, I'm agreeing with you. I'm trying to consensus on this. I'll stipulate it made no sense.
That sounds like a game between Carlos and Nick, kind of a situation.
That's right. So what I was trying to say is that if we took a pluralist pursuit of dialogue and finding interpretive and jurisgenerative communities seriously, we look below a lot of the kind of formal things that we are seeing that you discuss in your paper. We consider, for example, valid claims to states' rights, right? Now, regardless of whether you can find them in the Amendment or not, we see communities of states through the National League of Cities or what have you. We see them articulating norms that establish communities that have claims that ought to be considered. We'd also see below the state, we'd say, claims that individuals have to establish principled discussions with their consular officials, right? To take two examples of right before this discussion. So I'm not at all sure I understand where the limits of the pluralistic discussion go, and if we can fault the existing pluralism for ignoring these things that don't come dressed up as though they have black letter rights affiliated with them somehow, but instead are communities that are trying to stay in place, often destructive. My bigger, that's more of a open question, and more in terms of open critique. It doesn't seem to me that the problem with international law is at all the lack of pluralism, right? International law, in the course of circumstance, not unlike habeas corpus, as it arose, is just trying to cope with very limited resources, very limited authority. And so, whether it likes it or not, basically there's an enormous amount of pluralism, very little hard line, final authoritative judgments, very little dialogue goes, right? So the problem is, so in that extent, your pluralism project is largely descriptive and largely accurate with the pretensions of the international legal system, putting aside those who believe, the kind of something about this, who are marginal in terms and inaccurate in describing international law. But you actually, in your paper, discuss a number of circumstances in which pluralism is being asserted out from under and in a destabilizing way in circumstances where international law has achieved some hard-won final authority, right? And so I'm asking, in these exceptional circumstances where you have inherently binding obligations, with rare cases where the ICJ has seized their jurisdiction, renders a final determination and asserts that it's binding in a way that actually seems cognizable and you actually have a shot at having a state conform with the judgment, right? The stars are aligning, right? Under those circumstances, right. So under those circumstances, imagine pluralism saying to a relevant actor with apparent authority, you are doing law, and you should be patting yourself on the back if you tell the ICJ to go jump in the lake, because after all, you're furthering the kind of discussion that is fundamental to the legal order and is the best we can possibly hope for in any case for us. To me, that is enormously destructive. And I wonder, even if we can see the payoff you're envisioning, one of the issues certainly that exists, if we can speak realistically and crudely here, is that the international legal system does not have the capacity to generate community that other communities have. There's this discussion of lack of demos, even within Europe, right? How we might imagine saying to these states that are rivals for resources and capacity and are trying to kill each other in many circumstances, how we can say that acquiescing to a certain number of basic primitive rules is in tension with pluralism. I realize you probably would say, well, that's just an example of a rule that's external or something like that. But I guess it seems to me unrealistic and dangerous.
Okay, I was with you until all the way at the very end. But,
Okay, good.
okay, so
More than that.
first of all, two comments from just before. It's important to recognize that a pluralist position is skeptical of national law also. So it's not that, as I said, international law may be more, but less legitimate in the sense that national law also, to a pluralist, is not the end of the conversation and is not, the only potentially relevant sphere. Also, which causes me to resist some of the anti-international law arguments that strong nationalists make. Also, just as a quick point, I don't think I would resist the constant refrain that international law is less democratic than national law, to the extent that, say, you might think international human rights are a necessary precondition to functioning of democracy. It would support democratic processes to the extent that having an international regime prevents or retards government capture on the national level, say by industry. A trade regime could be seen as serving democratic functions, etc. I just don't think that you can just sort of say that, as people do all the time, as a truism. With regard to Ed's points, your first point, which was sort of more of a question, had to do with, kind of where's the stopping place, I guess is the way I would say it. And pluralists always get that. There has been a long debate among legal anthropologists and others, and it sort of devolves into the what is law question, right? So once you pay attention to legal or quasi-legal orders that are not just official state orders, then the question is kind of where do you stop? And everyone has sort of different places that they stop or that they don't, and there were long debates within anthropology about what is law and what is social order. And I think that they were largely fruitless. There is no place that you can draw that line, and different people will do it differently for different strategic purposes at different times and so forth. And so the debate kind of got left. That's not a big deal to the degree that pluralism is being used as a descriptive project. It's more of a big deal to the degree that you're using pluralism as a normative project. And part of what's complicated and quite difficult, and I would say problematic, about what it is that I'm trying to gesture towards is that I'm trying to transform a descriptive discourse into something that has a tiny bit of normative bite. I'm not trying to make really, really strong normative arguments about how cases should come out or things like that, but that there are certain values that, first of all, we should recognize just are going to happen as a matter of descriptive reality, and so we should pay attention to them, think about them, and take them into account. And then that there might even be some advantages to taking them into account. And that's probably as far as I want to go with the normative argument that I'm trying to make. So I do recognize that that's a problem, particularly when we don't have a stopping point. Now, on the destabilizing point, that's interesting, and I have heard that complaint before, that to the extent, that international law has tried very hard for several decades to convince everyone that it's law, and now I'm coming along and saying, oh, well, it doesn't really matter if it's law or not, it's just sort of a bunch of nuance of people saying things. And that to the extent that the international law project has been successful in convincing people that it's law and should be followed, that sort of entering into this idea that, well, we don't have to worry about that question is destabilizing. I don't think so. I think because I don't see that as a fundamentally different question from what happens about law anytime, right? So that any court, any legislature makes a statement of law, and it rests to some degree on whether other actors are convinced that that's law that they want to follow, whether it's police officers or whether it's individuals through protest or whether it's low-level bureaucrats through the way they subvert or change the way the norm is actually enforced on the ground. And there's millions of examples and so forth. That's something that happens whether you're talking about state law or non-state law. And I think recognizing that, I don't see as necessarily destabilizing or somehow making it less law or less important to the degree that the ICJ or anybody else can convince, as an empirical matter, a lot of people around the world that they should pay attention, or that Garzón can convince people in Argentina that these human rights abuses should no longer get amnesty, then that has real impact on the world. And I don't actually agree that it's impossible or even necessarily more difficult to get an epistemic community around certain ideas on the international level, necessarily that's harder than doing it on the national level or at the state or the locality, etc. I think actually for certain kinds of broad norms you get more agreement. I think you could get more agreement in my town of West Hartford to international human rights norms than you could to whether a shopping center should be located.
That's incredibly specific.
I understand, but
whether human rights would bar the city park from doing proposed action X, you have the same degree of disagreement.
I was actually going to say, because just a wee bit is what I hear you is making kind of the pure normative, and I think part of what's going on there is the process that I'm hearing you, and I'm thinking to myself, yeah, except for the fact that, when has the ICJ ever worked? Right? And here you have the one opportunity it might actually work. It's not like where you were Supreme Court, and you have a long 100 years history of compliance. You don't have a history of compliance with the ICJ.
Right.
In fact, one could argue that it's maybe 50-50 at best, probably less than 50% of the time. And so I just wonder if you're not really two different poles when you're positing and saying, oh, we're kind of in the same. State courts and the international court are just
there are different traditions, there are different histories, and there are different conventionalities that have grown up over time. I guess it probably depends on what works means.
I guess just like I see that
the possibility of developing that kind of sort of more regularized compliance over time, just as the U.S. Supreme Court does.
Right, but at some point they have to be successful before you can get to regularized compliance, and I think part of the problem is...
I got two people on the list, and we're running out of time. So
in terms of sort of picking up on this and responding to Ed's question, so one thing as to the sort of other entities, I want to sort of take a slightly different position from Paul. That I actually think you can tell a story. It doesn't have the sort of the theoretical coherence of Paul's description of it. It's impossible to distinguish. But one can tell a story about we are going to privilege public assertions of law or public assertions of authority in a way different than we're going to privilege non-public ones. That doesn't, again, necessarily, that will not align perfectly with the relevant dynamics of persuasiveness and sort of rhetorical force of various, so in some cases, in fact, someone may be more committed to their boldly than to their nation. But, as a general matter, it may be that sort of that rough allocation or that rough demarcation works. So again, that's not to dispute. If I understand your point to be that, where does it is sort of equal, so where does it stop? I agree with sort of that there's a scale in some sense rather than bullet point, but we nonetheless can draw lines in the way we do in other contexts as a matter of the functionality of the system. So that was sort of my point on that point. As to sort of the circumstances in which international law has been victorious. Dr. Glassman was sort of this opportunity of success, or it works, that sort of Paul was trying to respond to. That's the question in some sense, is what's the overall project we're talking about? What is it that we're aspiring to? What we're aspiring to is for international law to function the way that we conceive of national law functioning, then you're absolutely right. But if in fact, again, and Paul's project ultimately is sort of more ambitious in some sense than mine is, but if the project is to sort of reconceptualize the way we think about sort of the way law functions, then it seems to me, then the answer is, well, it's understandable that in these few, as you put it, sort of hard-won victories, it feels like, we're grabbing, defeat from the jaws of success. But if we're talking about a very entirely different paradigm, then that doesn't work. You go ahead and respond, but I would think. So let me just say a couple other things. In some sense, for me, it's a question of, what we're shifting to is a notion that, that the ICJ is engaged in certain assertions of authority, right? And the question becomes, what's the persuasive force of those assertions, right? So if they have persuasive force, they have a certain efficacy. That, I think, is in some sense the story we began with, right? Holland versus Missouri is a good law. What was that discussion? I mean, is the question, is it still binding law according to the U.S. Supreme Court? All right, so it's possible that it's been partially overruled by Reed versus Colbert, but for the most part, yeah, sure, it's good law. But what actually happens with it? Does it have rhetorical force in these negotiations or in the interaction of federal and state authorities is really, in some sense, the question. And that seems to me is the same story at the international level. To draw that parallel, one other piece, I looked in the computer to find this quote. I'm very interested in sort of the translation issue of sort of to what extent does our embrace of patterns of jurisdictional overlap and so on and so forth in domestic settings, tell us something about the international setting. So the quote is William Riker writes in '64, if in the United States one disapproves of racism, one should disapprove of federalism. So this is if one disapproves of racism, one should disapprove of federalism.
He created that in the 1980s.
He did, all right, so it came around. No, and I'm not endorsing necessarily for the substance of it, but to say that sort of, in some sense, going to sort of the international norms being threatened, that's the same domestic question, right? We can tell that same story that, are you really going to embrace states' rights? Are you going to embrace the notion that states should have a meaningful voice? And does that mean you're abandoning the normative principle of race equality or whatnot? Similarly, does embracing some notion of pluralism in transnational settings mean, or is it equated with abandoning the principles of universalism that you're
Carlos was the last one on my list.
Is there still time?
There's time for you, and then I get time.
Okay. Well, just a brief comment. I had a similar reaction to Ed's, to Paul's normative as opposed to prescriptive project. I mean, as a descriptive matter, I agree that contestation will happen no matter what. There will still be contestation. There will still be pluralism. Although I do think you understate the capacity of law to settle things, at least for a time. When the Supreme Court decides that U.S. law requires something, police officers will, you can contest that, but if you violate the law, you will be sent to jail. To take a simple example. But I resist the normative part of your analysis. Pluralism will happen, but my inclination or my preference is in the opposite direction. That decision makers, you're arguing decision makers should sort of lean in favor of more pluralism, leaving things open more, rendering decisions that facilitate a continuing conversation. The opposite, I lean towards the opposite view that law should take pluralism and try to settle things as much as it can for a time, at least in many circumstances. My question is, are these necessarily opposite preferences, and does the question then boil down to whether leaving things unsettled, encouraging pluralism, is better than settling things and having a degree of settlement? Or are you saying that there are circumstances in which one is better and other circumstances in which the other is better, and you invent a theory of when one is appropriate as opposed to the other? Or does it boil down to whether you like the settlement or not? I mean, the Garcon example, you could tell a counter story. To many people, it's lamentable that Argentina went through a process, settled things for a while, and wanted to get on with it and do something, focus on improving the quality of life in Argentina or something. And then Garcon comes from Spain and unsettles things. Would you feel the same way about whether that was a good thing or a bad thing if Argentina's settlement had been to prosecute, say, Chile prosecute Pinochet, and Garcon comes, or Spain comes in and grabs him and gives him asylum, unsettled things in the opposite direction? Is desirability of settlement ultimately depending on what the settlement is.
Okay, so very quickly, all I'm saying is that pluralism is a value. I'm not saying it's the only one or that it trumps all other values. This is sort of my response to Anthony yesterday. So that if there were a circumstance, so it's not saying that in all circumstances you should favor pluralism over trying to assert a norm or trying to stamp out other alternative interpretations. There may be times when individual decision makers think it is extraordinarily important to stamp out, some alternative interpretation, and they'll try to do that. And all I'm saying is that they should justify trying to do that in the way that Bob covered, as I mentioned in my paper, things that if you're going to deny a tax exemption to Bob Jones University, you need to justify it by placing the 14th Amendment and the equality norm on the scale and say this is an incredibly important national commitment and that justifies it. So it doesn't prevent that from happening. As to the result point of view, that's a political contestation point. So I would, as a political actor, I would take the position that I would be more supportive of Garzon in one situation and less supportive of Garzon in the other situation. But I would recognize that both of them are assertions of overlapping jurisdiction that you are not going to be able to shut down even if you try to, and that the act of having the two entities made it possible and makes it possible for someone shut down in one system to go to the other system. Now, in one case, I
shuts down settlement.
Right. So in one case, it allowed, human rights plaintiffs a voice, and so I tend to favor that better than one that would favor, giving asylum to human rights violators a voice. But I would recognize that both of them are, because of the overlap, are providing multiple nodes. And I just, politically or whatever, would resist one, but as a normative matter, but I would recognize as a structural, procedural matter, that they're both doing the same thing.
Just the one sentence, and I would say, for my version of it, would be something like on the whole, if the notion is that the structure sort of give greater voice to more actors, on the whole, we can expect better normative results on the average, right? So we will more often sort of get Garzon doing what he did as opposed to the reverse. But you're absolutely, but I don't dispute for a moment that sort of you will have those cases as well, and it seems to me that I agree.
Well, we are beyond out of time, so we don't get to do the naval games, and I hope we have a few minutes to do what we can.
You want to segue into this?
So, you want to segue?
Well, I don't know how many of you saw Dante posted on the yours point and notice about the conference, and then Marty.
Well, yeah, I was going to talk about that.
Oh, okay, go ahead. Yeah.
Well, you can tell the story now.
So Marty Letterman puts a comment up saying, which basically says,
Why are you
you're all very nice people, and why are you wasting your time talking about Missouri versus Holland?
Now, I didn't want to announce that at the beginning of
So are you guys going to post a response?
I did.
Well, no,
Marty's coming to my conference.
the webcast. The response will be on the webcast, and the final papers will be published in the Symposium issue. Tommy's in the back if you need to talk about publishing deadlines. No, but I one of the marks of a good symposium, a good conference, is learning a lot, I think, at least from my perspective. And I learned a ton. Lots of things I'm digesting, I think, in these months to come. Really terrific papers, really terrific conversations. I'm really appreciative that you all could make it to Missouri, as we like to call it. And it's sort of some of the conversation this morning makes me realize, there's even, you can envision expanding this group because we are American scholars and we are coming at these issues from a particular perspective. I try to step out of my own preferences and talk about the International Law Project, which is a deeply held both ideological and academic perspective among both colleagues here in the United States, but especially as Berlin has discovered among our colleagues from across the water. And so you can imagine this discussion about federalism and international law expanding to include other federal systems, and to include certainly Europeans and their experiences. And when I do a conference like this again, which won't be for at least 10 years. And one final point, this discussion of fragmentation and competition and all these interesting things descriptively that are happening, and this is sort of a point about where the scholarship is going. There's so much happening and there's so much room for more empirical examination, I think. But a lot of these questions we're not going to know the answers to, in friends, until it's too late, maybe. But I think there is serious concern about what's happening, and I appreciate that people like Bobby who embrace complexity and sort of, walk in the shoes of complexity and feel comfortable with it. But there's a lot of great challenges for our scholarship, I think, challenges and opportunities and lots of fun and exciting things. So I appreciate all your contributions to that larger dialogue. And lunches are just on the housekeeping. We've got lunch. We've got lunches for those who want to take a lunch. Anyone who's going to spend more time in town, we can talk about walking downtown, seeing the sights. And I should, because I know Ed really wants me to say this, there is this Churchill Museum in the basement of the Christopher Wren Chapel that was moved stone by stone from London. That's just down the highway in Holland, Missouri, for those of you who are interested in Churchillian history.
Tour there.
You could call ahead and get a special tour. No, it's a very small museum, but it's very well done. So, it's sort of a bookend at the beginning of the Iron Curtain speech, and Missouri and Holland being important cases for this geographic territory. So, thank you again for all of your time. Thank you.
And thank you for the students as well.
Yes.
Yeah, thank you to Bill and Chuck and all of you for having listened.
I was going to say, automatic.